Raymond is an environmental lawyer that currently lives in Washington State. He served for 20 years in the U.S. Air Force, including 5 years as the environmental attorney for Strategic Air Command and 4 years in San Francisco as an environmental counsel for the Western States. And he retired as a lieutenant colonel. After several years with the Ballard Spahr law firm in Salt Lake, he joined Bechtel Engineering in contract with the U.S. Department of Energy to clean up nuclear reactors in a site in Southeast Washington. And then he spent 8 years in the Idaho National Library. Is that, or laboratory? Is that
laboratory?
Correct? And so he retired in 2019, and altogether has 40 years experience involving environmental issues, including radioactive and hazardous waste, air and water pollution, wildlife protection, and environmental impact analysis in 30 states. He currently teaches environmental law and constitutional law for Washington State University in Pullman, Vancouver, and the Tri-City area. He's also been an adjunct for University of Idaho, Utah Valley University, and St. Mary's College of California at Moraga. Hopefully I said that right. So as you can see, he's got a lot of experience, which is why I wanted to hear from him today. So without further ado, Raymond, if you'd like to take it away, I'll stop talking and turn it over to you.
Let's see. So I've titled this Restoring Local Control of Wetland Protection. And looking at the positive side of the Supreme Court's decision that it issued at the end of May in Sackett versus EPA. This case concerns a piece of property owned by the Sackett family up in the northern panhandle of Idaho. The lake here is Priest Lake. The property at issue is inside this dotted line. You can see that it's not bordering on the lake itself, but the EPA claimed about 16 years ago that the land constituted wetlands, and that if the family went ahead to do construction for a home, like all of these houses up here, that they would be prosecuted under the law for criminal violation of the Clean Water Act, because their land is a wetland, and according to EPA and the U.S. Army Corps of Engineers, it is adjacent to a body of water that flows into navigable waters. So that's and this is a case that's been going on. It's already been to the Supreme Court once before, but Priest Lake, this is not exactly to scale, but this is sort of a tourist map in the panhandle just south of the Canadian border. And that photo is over here on the western shore of the lake. It drains through Priest River into the Pend d'Oreille River, which drains Lake Pend d'Oreille. And you can see from this map, Lake Pend d'Oreille is a tributary of the Columbia River. It actually goes up, crosses the Canadian border to do that. And then the Columbia River drains down, forms a border between Washington and Oregon and out to the Pacific Ocean. And I live right in here at that bend in the river. Okay. Now, the way this matter ties into church teachings is the provisions that are in the Doctrine and Covenants that talk about our relationship to government and our duty to obey the law and conform to the law at the same time that the government has the obligation to protect us in our rights, including our rights to control property. And so this is, I think, to a great extent unique among Christian denominations in that we have a formal belief that the government of the United States was created specifically to protect the rights that are important to the restoration of the gospel. Back in 1830, when the church was officially organized, the constitutional law was already well established by Congress, the president, and the Supreme Court, that the federal government had authority to regulate rivers and seas and other surface waters under Article 1, Section 8 of the U.S. Constitution, which is called the Interstate Commerce Clause. And those bodies were referred to by the term navigable waters because they allowed people and goods to travel on the surface of the water in interstate commerce, and therefore was subject to the federal government's regulation. Other surface waters that did not fall into that category were left to regulation by the states. So that's a dividing line between the extent of federal versus state authority. And within the federal government's authority, it is the supreme law of the land. That is, it overrides any conflicting state laws as provided under Article 6 of the Constitution. Well, okay. So in this recent decision by the Supreme Court ruled 9-0 in favor of the plaintiffs. That's not something that is emphasized a lot in the news coverage, that all 9 of the justices actually agreed in favor of the property owner and against EPA, that EPA should not be imposing regulation on that piece of property. Now, there were several opinions attached to it. The majority, the 5-justice majority of the court that specified a specific rule for why the EPA did not have jurisdiction over the Sackett's property, stated that the rule should be that the EPA should only be able to regulate wetlands that actually have water flowing from them into ultimately navigable waters that are subject to federal jurisdiction, and not regulate a wetland that or an isolated pond that did not actually have water flowing from it into navigable streams like the Columbia River. And it was fairly clear from the facts of this case that because of the setback of the Sackett's property and the road in between their property and the properties adjacent to the lake, that none of the water that fell on or flowed onto their land actually affected the quality of the water in the lake or any of the downstream rivers in any way. And so all 9 of the justices agreed it was inappropriate for EPA to regulate their property. So again, the rule as stated by the Supreme Court majority was that, and is that EPA's authority to regulate wetlands is limited to those which actually have water flowing from them into ultimately navigable waters like the Columbia River. There's been a lot of hysteria in the news coverage about the decision, claiming that the Supreme Court had cut off all EPA and Corps of Engineers regulation of all wetlands, which is not the case. the wetlands which are actually touching navigable rivers and their tributaries, and that actually carry water and potentially pollution into those traditionally federally regulated navigable waters, are still under EPA and Corps of Engineers jurisdiction. But this piece of land is not. It's isolated. The waters on their property do not reach the Columbia River. Okay. So people need to be a little more circumspect about how the court's decision is actually limited. This is a map that shows a little distribution of the level to which various states regulate surface waters, including wetlands. Those in the light blue have statutes that specifically address pollution in surface waters or wetlands, regardless of whether the water from them flows into federally regulated navigable waters. In California, where I worked for several years, it's called the Porter-Cologne Act, named after a couple of assemblymen. Sounds like it has to do with aftershave, Porter's Cologne. But they have various levels of active regulation of that under state law. Most of the remaining states have regulated wetlands by delegation from EPA and from the Corps of Engineers. At the time that the Sackett case arose, Idaho was not actually doing that. And to a great extent, it was the only state in the country that was not trying to enforce the Clean Water Act by delegation from the federal government. And that's why EPA is directly involved in this case rather than the state. But with the new limits that the Supreme Court has reiterated on the extent to which EPA can regulate isolated ponds or wetlands, there's additional responsibility placed on the states to decide how they want to regulate those kinds of areas. Now, conventionally, under the federal law, wetlands are defined by having three characteristics. All of them have to be there. First of all, at least 2 weeks of the year, the land has to be inundated, basically underwater. And then a sample of the soils have to show that the soils are of a kind that shows that they are regularly saturated. They're fully soaked with water, and that a sampling of vegetation across that land shows that the plants are predominantly those that like to live in saturated soils. And if you have all three of those characteristics that you can establish, then they meet the federal definition of being a wetland. Wetlands have been recognized as having a great deal of value to ecosystems. They provide habitat for lots of different fish and birds, animals, trees, and other plants. When their water flows into tributaries of rivers or the sea, they provide spawning sites for many aquatic species. They also support migrating birds and animals and provide, obviously, recreational opportunities such as fishing and hunting and so forth. Given the way the wetlands are defined, during most of the year, a lot of wetlands look like perfectly dry, normal, forest and wildlands. But they can have this function because they receive water and become saturated. Wetlands that are actually adjacent to rivers can purify surface water from biological pollutants such as animal waste. And then there are, in fact, some smaller towns that can use marshlands that are particularly designed for the purpose to purify their municipal sewage water. And it can do it just as well as a conventional mechanical sewage treatment plant with the rotating arms above beds of rocks and so on and so forth. And takes a lot less energy and cost, and has the side benefit of actually functioning as a wetland or marsh in the biosphere. And wetlands also help to prevent flooding. They divert rainwater into the ground, into aquifers, and so help to prevent various kinds of floods and so forth. So preserving wetlands has all of those benefits, especially if they are actually connected to rivers and streams that flow down and join larger bodies of water. Now, in addition to the federal government's authority over navigable waters, states and local governments have long held a traditional police power to regulate and protect the natural environment within their borders. Since the early days in the United States, the first federal agency that had any kind of scientific expertise was the Army Corps of Engineers. It was initially the only engineering school in the country. And so Congress assigned to the Corps of Engineers a lot of the scientifically related responsibilities of the federal government, including maintaining the navigability of major rivers such as the Mississippi, Missouri, Ohio, Columbia, and the Colorado River, and the Great Lakes and coastal waters as well. They regulate the placement of riprap, which could be either large rocks or concrete forms that are laid on the banks of waters and to prevent erosion. They build levees for flood control. Unfortunately, they didn't do that good a job in New Orleans prior to Hurricane Katrina. They've had to revisit that. The Corps of Engineers helps to either construct or supervise or authorize the construction of dams and ship locks. They also, therefore, support irrigation, generation of electric power, help to control floods, and enable movement of goods and people up and downstream. Okay. Now, the Supreme Court has using the federal government's authority issued a number of rules interpreting the law over the years. One of them is the equal footing doctrine, which declares that when a state joins the United States, then all of the land underneath the navigable waters at that time become property of the state rather than the federal government. And back in 1983, the state of Utah won a decision from the Supreme Court that the state, rather than the federal government, owns the bed of the Great Salt Lake, which is billions of dollars worth of mineral salts. Here in Washington State, near where I live, the federal government for the Manhattan Project took over about 600 square miles of land, and they needed water from the Columbia River to run the nuclear reactors that made plutonium. And so the government took over from the state of Washington the bed of the Columbia River, and for about 30 miles, and it still owns that. The ownership of water is governed by state law, although federal agencies and Indian tribes have preemptive rights to those waters. Okay. Now, the Clean Water Act specifically gives to the Corps of Engineers the authority over anyone placing physical materials into navigable waters, and EPA has the authority to regulate the discharge of pollutants into those waters. So the system they generally use is they prohibit any kind of discharge, either of sand or silt or physical materials or pollutants, unless a party gets a permit from one of the agencies. Now, for a wetland, if you want to develop that wetland and alter it, build something on it, it can be very costly. Typical, an average cost is on the order of $250,000 because you have to prepare an environmental impact study. You have to purchase replacement wetlands somewhere on a ratio of 3 to 1, 3 acres for every acre you are changing from wetland status. And there are companies that make a living creating new wetlands so that they can sell the ownership of those wetlands to people who want to develop their wetlands. Acting without a permit from these agencies can result in very severe financial penalties as well as criminal penalties and imprisonment. The Clean Water Act also allows the agencies to delegate their programs and the day-to-day enforcement programs to the states, okay, as long as they are as strict as the federal programs. Okay. During the New Deal, the Congress enacted a number of laws to basically regulate the economy in a fairly minute way. And the Supreme Court went along and said that the Interstate Commerce Clause allowed any activity that involves the flow of money across state lines to be regulated by the federal government. And that's very extensive. That's very distinct from the way the federal government has traditionally regulated navigable waters, where ships and boats can move up and down them, carrying goods and people. In 2001, the Supreme Court started issuing decisions pulling back on the EPA and Corps of Engineers authority. The Corps and EPA had passed regulations claiming that they had full Commerce Clause jurisdiction over anything that touched the flow of money rather than the flow of water. And so they claimed in one case that the fact that a rock quarry that the city of Chicago wanted to use as a landfill and happened to get rainwater down the bottom of it, even though the water did not flow out and go into Lake Michigan, for example, that the Corps of Engineers claimed that because birds that migrated across state lines would go down and drink the water, that the city of Chicago needed to get a permit from the Corps of Engineers before they could use that quarry as a landfill. And the city, having enough money and time, appealed to the Supreme Court and won that case. The solid waste agencies of Northern Cook County against the Corps of Engineers. And for the first time, the Supreme Court told the federal agencies that they needed to cut back on their claims of jurisdiction over surface waters, ponds, wetlands that did not actually flow into the traditional federal navigable waters. However, we had based on that decision, when I was at the Idaho National Laboratory, we persuaded the EPA that the Big Lost River was not, in fact, navigable waters under federal jurisdiction, under EPA's jurisdiction, and we could stop shelling out $1 million a year in compliance costs under the Clean Water Act for stormwater pollution prevention, since the Big Lost River does not actually flow into the Snake River, the nearest navigable stream, but rather just sinks into the ground. It goes down into the Snake River aquifer underneath the river, and it takes about 200 years to flow 200 miles out to some springs where it comes out of the ground and enters the Snake River south of Boise. In 2006, there was another case at the Supreme Court where the Supreme Court again told the Corps and EPA that they should not be regulating wetlands that didn't actually flow into navigable waters that were a federal concern. But because the justices that voted in the majority could not agree on the rationale, the reason for the ruling, it left a good deal of confusion. And in the meantime, EPA and the Corps continued to push the limits of their authority. Then in 2012, a Supreme Court unanimous decision, and this is the first time the Sackett family got to the Supreme Court, ruled that EPA did not have authority to prosecute the Sackett family based on their conclusion that it was wetlands, that the Sacketts had a right under the due process of law clause of the Fifth Amendment of the Constitution to have a court hearing on EPA's claim that they had jurisdiction over the Sackett's property. But it took another 10 years before they got back to the Supreme Court on the actual question of whether or not their land was a jurisdictional wetland that EPA could regulate. And again, the Supreme Court ruled 9-0 in favor of the landowners. Okay. The majority opinion signed by 5 of the justices adopted a very simple, straightforward rule that for EPA to assert jurisdiction over a wetland, it had to actually have waters flowing from the wetland into streams that eventually became navigable waters under federal jurisdiction, so that it could actually carry pollution. But if there was not that flow of water off of the land, by definition, it could not carry pollution. It could not be a source of pollution because the water wasn't flowing from it into navigable waters. So if it didn't actually pollute the navigable waters, there was no basis for EPA and the Corps to have jurisdiction over that land. There were the other 4 justices, including Justice Kavanaugh, who didn't like that particular formulation, but when you read their concurring opinions, they didn't really come up with any other coherent rule. And they agreed that EPA had overreached in trying to regulate the Sackett family's land. There are some environmental groups that have responded to this, claiming that half of the wetlands in the United States don't have any surface water flow into navigable waters. And that EPA is losing its authority to control the use of those wetlands. But again, by definition, these are wetlands that don't carry pollution into any of the navigable waters. So EPA's interest in those wetlands, those isolated wetlands, is of a completely different nature than protecting against water pollution. It is something about, we should regulate land use because of managing ecosystems and things of that nature. But it has nothing to do with preventing water pollution. Okay. Now, states have always had the authority to regulate land use in general, including protecting the environment. Again, the states around the country have different levels of their own state laws and regulations governing potential wetlands and isolated ponds and so forth that don't flow into navigable streams. So there's nothing restricting the states from enacting their own sets of regulations. Most of them had already been implementing EPA and Corps of Engineers regulations on the matter, and so it's not like they have to reinvent the wheel. They know what kinds of terms they can use, and they can pass additional statutory authority if they need to appropriately regulate wetlands that don't pollute the navigable waters. Okay. So as states do this, they can have the option of following EPA and Corps of Engineers practice, which is to require a property owner to apply for a permit if they're going to modify an isolated wetland. Like EPA, make the owner pay the cost of preparing an environmental impact study, buying rights in the wetland bank for replacement wetlands, and doing other analysis, such as paying the cost of having the exact limits of the wetlands delineated through scientific sampling and so forth, and determining what exactly is an appropriate level of regulation of their use of the land. That kind of regulatory approach, like the one that EPA uses, places a financial burden and a burden of delay on property owners. But if states adopt that permitting approach, as already happens in many states like California, when that permit is being proposed for approval, people who have complaints about the nature of the proposed permit can file objections to it orally, in writing, and then once the state determines to issue a final permit, they can go to court to object that the state acted unreasonably in issuing the permit. And so, citizens can continue to participate in those kinds of permitting decisions. Now, another option, another tool that's available at the state and local level is to use the power of eminent domain, just as states and local governments can take private property in order to build a road, for example. If they believe that a particular piece of wetland that doesn't flow into navigable rivers, but purely as a matter of the ecosystem, if that wetland is so important that it needs to be preserved, state and local governments have the authority to use their eminent domain power to take over that property and simply compensate the owner for the value of the property, the reasonable value. That's something that's always been available to EPA and the Corps of Engineers to do, but they would rather have property owners pay costs rather than the federal government pay the costs of preserving wetlands and turn them into federal lands in essence. If you're the property owner, you can contest the amount of money you're being paid, it's much more difficult to contest the state's reasons for taking your property. Uh, the state basically gets a lot of leeway in most cases for making that decision. But again, because those kinds of decisions, either in the permitting process or in a process of the states taking over wetlands that have ecological value to the state and paying the property owners for it. Those are at the state and local level, and they are therefore much easier for us as citizens of our communities and its states to affect in terms of those policies. And frankly, a lot of the objections to EPA and the Corps of Engineers interference with private property owners' use of land would dissipate if they had simply gone out and bought the land from people. But again, they're being cheap and they don't want to ask Congress for the money to do that. So they would rather make landowners shell out those costs. Again, hundreds of thousands of dollars in many cases in order to comply with the EPA's requirements. So that's basically where we're at. First of all, the wetlands that have the most significant effect on rivers and streams and so forth are still covered according to the EPA's rule, rather the Supreme Court's decision on what the EPA's authority should be. That is, wetlands that can affect adversely water quality in rivers and streams and lakes and the ocean are regulated. They can be properly regulated under the Supreme Court's rule because water flows from them into those rivers and streams and so forth. If wetlands are isolated and they don't affect the water quality of federal jurisdiction navigable waters, then there is much less of a federal interest in them. And the Supreme Court has said those are left to the states to regulate. And states, in many cases, already have programs for doing that they can use. And other states can pass laws to do the same thing. So rather than saying, oh my gosh, all the wetlands are going to disappear, this is simply an opportunity for states and local governments and citizens to take greater responsibility for deciding how to best preserve wetlands that are not draining into navigable waters. So are there any questions?
Yeah, here, I'll jump in real quick. Thank you, Raymond. That was interesting. I learned a lot of new stuff. I didn't know a lot about that. So thank you for sharing.